So let's talk about the trial. Now, if you watch movies and television, you're probably familiar with every single aspect of the trial process, but you may never have thought of them in the right order. And first of all, that's true because trials almost never happen. In federal court, I can easily go a year or even 2 years between trials, because unlike civil trials, where two parties are arguing with each other, or traffic hearings that are a really pretty common type of trial because they have low stakes, in federal court, trials involve a huge potential difficulty for the defendant if they're convicted. They may get years longer in prison if they lose. So we normally only go to trial if we really think we have a chance at winning. So at a criminal trial, the only question is the legal guilt of my client. So it doesn't matter if people feel bad for my client or they think that, it's really kind of too bad this person's going to get convicted. All that matters is, has the prosecutor proven beyond a reasonable doubt the exact elements required in this case? Now, that's different than factual guilt. Factual guilt is, did the person do it? Legal guilt is, did they do something that the law says is not allowed, and have their actions been proven beyond a reasonable doubt, and there are no defenses to those actions? In both state and federal court, most cases go to the jury, although sometimes it's possible to have a bench trial, especially for misdemeanors. But that requires the consent of both parties. The jury trial process normally starts with jury selection, opening statements, the presentation of evidence, closing arguments, the judge's charge to the jury, that's where the judge tells the jury what the law means, deliberations, and then the verdict. And there is a very big difference between statements and arguments. An opening statement has to be limited to the facts. The prosecutor and the defense attorney can say things like, the facts will show that the defendant went to the house that night with a gun in his hand. That is not an argument. They're pretty similar, but think of it this way. The prosecutor can say the defendant went to the house with a gun in his hand. The prosecutor can't say the defendant was an evil man who went to the house that night with the most wretched and dastardly of plans in his head. The presentation of evidence is just witnesses, physical evidence, anything that is brought into court and that the jury then hears about. There are two types of evidence. We talk about direct evidence. For instance, if I walk outside tonight and I see rain falling, I can say that's direct evidence that it's raining. Circumstantial evidence is evidence that I have to interpret. If I walk outside and my lawn is wet and my car is wet and everywhere I look is wet and there are clouds drifting away on the horizon, I might say, you know what, that's pretty good circumstantial evidence that it just rained. Now here's the thing. Even though we talk about those terms on television and in the movies, and even in this class, one of the first things a judge does is tell the jury there is no legal difference between direct and circumstantial evidence. It's up to the jury to decide what evidence is important and how much weight to give it. Hearsay are statements that are made out of court. So if I walk into court and I say that man over there is the robber, that is not hearsay. If my friend Michael walks into court and says, Troy pointed at that guy over there and said that guy is the robber, that is a hearsay statement. It is an out-of-court statement that is being offered for the truth of the matter asserted, that guy over there is a robber. There are lots of hearsay exceptions, and those are all situations where we say, you know what, that statement, when it was being made, was not intended to be used as evidence at trial. And, like a dying declaration, if I'm dying and I say, I can't believe Michelle killed me, that I'm not thinking about trial, I'm thinking about the fact that I'm dying. Or if I say something like, oh no, that red car's about to hit that kid, I'm not saying that because I think the driver of the red car may someday go on trial. I am just yelling out what I'm seeing. So the prosecutor presents evidence and calls witnesses, and the way they normally do that is through something called direct examination. They bring in a witness, and they can't say, that man over there is the robber, isn't he? They have to say something like, do you see the robber here in the courtroom today? Can you identify him or her for us, please? That's the format of direct examination. The defense then gets to stand up and cross-examine the witness. And cross-examination is where you can suggest the answer in the question. You can say things like, well, you didn't really think about it before you pulled that gun out, did you, sir? And that is totally permissible during cross-examination. At the end of all the government's evidence, they make a formal statement that the prosecution or the government rests. That means their case is closed and they cannot offer any new evidence unless something happens to allow them to do that. And the way that would normally happen is the defense calls some new witnesses, and then the prosecutor might say to the judge, Judge, we want to call some more witnesses in rebuttal to what the defense said. At the end of everybody's case, we have closing arguments. Now, at this point, no new evidence is allowed. If the prosecutor or the defense attorney says to themselves, oh my goodness, I forgot to bring up this point, chances are they're just out of luck. And the way it normally works is the prosecutor makes a closing argument, the defense attorney responds, and then the prosecutor gets a brief rebuttal to the defendant's argument because the prosecution carries the burden of proof. Now, in contrast to the opening statement, the closing argument is argument. You can argue any reasonable interpretation of the evidence that came out at trial. And a lot of times you argue things that were never argued during the trial. You get in little pieces of information and then you bring them all together and create an argument at the end. The judge then charges the jury, and what the judge normally does is reads a set of model jury instructions to the jurors and says, this is what the law means. Here are the 3 things that you are being asked to find. Here are the 4 things that you are being asked to find. Here's stuff that it's irrelevant. Now, sometimes the judge says some of this stuff before the trial begins, or may give a specific instruction during the trial at a certain point, and then gives a whole set of instructions at the end of the trial. Beyond a reasonable doubt is the standard for any criminal jury trial in the United States, and that means proof such that a reasonable person would really not have a doubt that the defendant is guilty as charged. It's not the elimination of all potential doubts, it's just the elimination of all reasonable doubts. The jury goes back to deliberate or think about it, and they normally choose a 4-person to be the head of that process. They then reach a decision. And although in federal court it has to be unanimous, in some cases in the military and in some state courts, it doesn't have to be unanimous. But whatever that threshold is, if they all reach it, they come back and they announce the findings. It might be a finding of guilt, it might be finding of innocence, or it might be a hung jury. If the jury just cannot decide, they can come back and tell the judge that. My very first jury trial, we could hear the jurors out in another room talking. We couldn't hear what they were saying, but we could tell they were talking. And over time, it got louder and louder and louder. And then a woman yelled out from the jury room, I don't care what they prove. That boy's yummy, and I ain't finding him guilty. A short time later, the jury came out and let us know that they were unable to make a decision. When that happened, all of us were worried that there would be a mistrial, that the judge would have to say, well, let's all come back on Monday with a whole new jury and we'll start over again. And there are a whole bunch of reasons why you could have a mistrial, but basically it's wherever the trial has gone wrong, there's not a fair trial or a final result, and so you just have to start over. But what happened in my case is that the judge gave an Allen charge, basically told the jury, get your behinds back in there. It's your job to come up to a decision. Go do it. And the jury did, and they came out with a finding of guilt in the drive-by shooting case in which I was the assistant prosecutor in Waterloo, Iowa back in 1994 or 1995. All right. They could also have come out with an acquittal, which would have been not guilty. And I've been on the receiving end of those before. Or they could do jury nullification. Now, jury nullification is the idea that John Grisham used in one of his movies. The idea that maybe a father finds out that his 3 kids have all been molested and attacked and goes out and shoots the man who did it. And goes in front of the jury on a charge of attempted murder, and the jury says, you know what? I don't care if he did it or not. That guy deserved to get shot. I'm not going to find this dad guilty. That would be jury nullification. Now, the interesting thing is, although the jury has the absolute right to nullify, in most systems, including in federal court, the defense attorney cannot ask for jury nullification or even argue that that is allowed to the jury. At that point, the jury comes back, they read the verdict, and the decision is then, if the person is not guilty, they can leave. If they're guilty, there has to be sentencing. And sentencing can either happen immediately or can be scheduled down the road. In federal court, where I practice, normally sentencing is about 3 to 4 months after the trial, because that gives the judge time to get a report all about the defendant so that the judge can figure out things like terms of supervision. Maybe my client robbed a bank, but the reason he robbed a bank is because he lost all of his money gambling and didn't have enough money to pay his kids' medical bills. So is the problem really that he's a bank robber, or is the problem that he is an out-of-control gambler? Well, in that case, you're going to punish him for the robbery, but you may have conditions of supervision to keep him from gambling, with the idea that if he doesn't gamble again, we won't have a robbery problem. Sentencing is guided by a number of principles. Proportionality, that the severity of the sentence should correspond to the severity of the crime. Equity, that similarly situated people should be treated similarly. Social debt, have you been a good citizen or a bad citizen? Where do you stand in terms of your relationship with society? Retribution is just the pure punishment that is deserved for doing something bad. And then incapacitation, which is we remove the person from this situation and it keeps them from doing anything bad. If you want to think of a real example of incapacitation, think of Old Yeller. Old Yeller saved a boy in the movie. He's a great dog, wonderful dog, but Old Yeller gets rabies. And Old Yeller has to be thrown in a cage, not because Old Yeller's a bad dog, but because we just have to protect people from Old Yeller and the rabies. Now, there are goals, deterrence. We can specifically deter that person from wanting to do it again. Or general. Everybody who hears about the case may say, ooh, man, Michael Vick got in that big a problem for fighting dogs against each other. I better not do that. We might also be looking at rehabilitation to improve the person and make them less likely to have problems in the future. Restoration is kind of similar, but that's where we're trying to make whole the victims and the community rather than the offender. In an indeterminate sentencing system, like some states have, a defense attorney and a prosecutor can walk in and make a whole huge range of arguments, and the judge could do anything from, say, 0 to 20 years of punishment, and there's no real standards about where to fall in between. That can have some unintended consequences. Some people said that led to judges being too soft on crime. Other people said, well, you get this crazy thing where a guy in Alabama gets a different punishment than a woman in Montana. So that led to the idea of structured sentencing, right, where a very specific number is provided for judges, and that's supposed to make people be treated equally. The problem is no two people are really alike. So determinate sentencing came in, and that's where specific punishments were set. Everybody who does this punishment or who does this crime will get this type of punishment. But that was a problem because, again, no two sorts of people are alike. And mandatory minimums were pushing the sentences ever higher, making it so judges had no choice as to what punishment to give. So then we moved to a semi-determinate sentencing system. That's where we have sentencing guidelines. It's kind of like the Kelly Blue Book of a car. What's a 2015 Honda Accord worth? Well, You start off by what model it is, what's its mileage, what special features does it have, and then you bargain with the car dealership about the cost. The same thing happens in court. It's a robbery. This amount of money was stolen. The guy used a gun. A teller was injured. That gives you a sticker price, and then the two parties go in and argue up or down from that starting point. And that idea of sentencing guidelines came about in 1984. The Federal Sentencing Guideline Act was created to create a commission to go study all the different crimes and come up with those guidelines. And the commission did that, and in 1987, 3 years later, those guidelines took effect. Now, what we have seen over time is that a disproportionate number of people who are sentenced in the United States are poorly educated, are minority males, and tend to be young. Now, there's one type of case that's radically different from every other, and that's called a capital case. If you are talking about a capital case, what you're talking about is a case where the government intends to execute somebody. And everybody I know, prosecutor and defense, always has a little phrase when we're talking about capital cases. We say, death is different. And that's because just about every single rule is different. Jury selection is different. Motions practice is different. You have to have specially qualified attorneys. The appeals process is going to be different. It is an incredibly cumbersome and difficult and expensive and lengthy process. I personally was involved, I think, in like 2008 with a hearing from a death penalty case from 1986, where the guy was still not done with his appeals, almost 20 years later. Gender and race on death row, again, we see disproportionate impact on minority populations. And public opinion has gone up and down over time. It's slowly starting to go down. Why? Well, there are some reasons for the death penalty. Some people truly are horrible, evil people. It means that they will never be around again to commit another crime. And sometimes the community is so outraged that it is a real cathartic thing for society. On the other hand, and why do I think death penalty support is falling? Well, it's morally inconsistent. It's applied unfairly. It's costly. It takes a long time. But the thing I really think driving it right now is we are seeing actual cases from the Innocence Project of people who we know did not commit the crime, who were found guilty, maybe have confessed, got put on death row, and some of them were even executed, and afterwards we learned they were innocent. Now, victims of crime in the criminal trial, as we talked about in other chapters, the role of the victim over time has changed, and it's only recently that the victims have gotten more input into their case. They are now consulted about things like plea bargains, trial decisions, sentencing, and that's because the federal government changed their rules. And the big rule change came in 2004 with the Crime Victims' Rights Act, which established a right of the victim to be involved in these parts of the process. And really that flowed out of the Timothy McVeigh trial, because there was a decision made in the 10th Circuit that the victims did not have a right to provide input on that, and that offended a lot of people. If you have any questions, if you have any comments, please let me know. I am happy to give examples.